everyone. Welcome to the 8th event that we have organized. We have one more left on December 15th, and then we will close the year and the Space Arbitration Talk series. But this one and all of the other ones will remain available on our website. So I want to thank again Thorsten, Chiara, Elena, and Spacewatch Global for hosting our events. I assume that most of the people who are joining these events are familiar with Spacewatch Global by now, but if not, have a look at their website and at the newsletters and the events, because I really think that they are giving a really good overview over what's happening in the space industry. So with this, we will turn to today's conference. And today's question is whether we can arbitrate harmful interference disputes. And it is a question that I personally find very fascinating and that I believe will become increasingly relevant in the coming years, although the panelists might disagree. We will hear about that in a moment. And this is why I'm glad to say that we could not have a better panel with us today to address this question. So we have Ruth Pritchard-Kelly from OneWeb, who will introduce the topic of harmful interference and its meaning for satellite operators. Mahulena Hofmann from Luxembourg University, who will focus on the ITU framework. Alexandre Vallet from the ITU itself, who will address dispute settlement mechanisms under the ITU rules. And finally, we have Tanja Masson-Zwaan from Leiden University, who will speak about the applicable rules to harmful interference under general international space law. So as always, I will introduce each of them in more detail throughout the conference. And we will now start with our first speaker, with Ruth Pritchard-Kelly. And she is an expert on satellite regulatory policy with over 30 years of experience. She's currently the Senior Advisor for Regulatory and Space Policy at OneWeb, where she advises a global team of legal and technical policy analysts. She also worked at O3B, now SES Networks, and American Mobile Satellite Corporation. She has a master's degree in space and telecommunications policy from George Washington University and a JD from the University of Maryland. She's on the board of the US Telecommunications Trainings Institute and is a member of the advisory committee for the Secure World Foundation. So as I mentioned, she will talk to us today about the topic of harmful interference and explain what it means for satellite operators. So with this, Ruth, the floor is yours, and thank you very much for joining us.
Thank you so much for that glowing introduction, Laura. You make me feel far more expert than I suspect I am, especially since I have seen not only who the other panelists are, but who the participants are who are listening today. So thank you to all of you for joining. I think you are all familiar with OneWeb, one of the new large low Earth orbit non-geostationary satellite constellations. We intend to be roughly 650 satellites, and we have roughly 450 already launched. We have another launch sometime in the next week or so. The windows are flexible with SpaceX out of Florida, which many people will recognize is the owner of Starlink, a direct competitor to OneWeb. But when it comes to launch vehicles and frankly, safety and responsible behavior in space, we are all on the same side. We will be at a 1,200 kilometer altitude. We are and will be, and that's important for issues of interference. We are using 12 planes. That's the circles in which the satellites orbit, and they are polar. And we use the Ku band for communications to our users and the Ka band for communications to our gateways. And all of this information is important for the different kinds of interference. There's physical interference, which has become a very big discussion in the last few years. Traffic, debris, conjunctions, collisions. And so that orbit and that altitude, and also as you rise into that altitude and as you deorbit, there will be physical approaches to other constellations, to other rockets, and of course to debris. And so that's important to know, the situational awareness. Then there's the radio spectrum interference, the traditional area where satellite communications has negotiated the sharing of the same spectrum globally for over 100 years almost. The satellites maybe not quite 100 years, but the ITU, as the experts on this panel will attest to, has overseen a very effective regime for that kind of interference. And then almost the newest awareness is the optical interference, light pollution, as some people call it, but the existence suddenly of hundreds and possibly thousands of new stars in the sky, objects that reflect light, has really awoken the astronomy community to a situation that they are very uncomfortable with. And so the hang time of how long you can see that satellite is important, and how reflective the satellite is, and how many there are. If you are only one or two, the way the geostationary satellites have been, and you're far away, that's a different kind of concern for optical astronomy than if you are very close and there are thousands of you. So there are three types, and I also would propose that there are three levels of harm. Is it merely irritating? Is it truly harmful? Does this absolutely restrict you from performing your purpose in outer space? Also, is it temporary or transient or permanent? And I think these different factors also are important in our discussion. Okay, I think that's what I was going to put forward as OneWeb's concerns and the areas that OneWeb is very active in all of these discussions, by the way. We certainly feel that as one of the main, we would call it a poster child in America. We, as OneWeb, are the face of the problem to many other communities. And so it is important to OneWeb that we participate and that we have discussions with all of the other users sharing the outer space environment. Thanks, Laura.
Thank you very much. So usually I ask questions directly after each speaker's presentation, but if that's okay, I will let the other speakers speak first, because I think it's good to have an overview over the applicable framework and then come back to you to see how OneWeb is dealing with this framework. So we will now turn to the second speaker, Professor Mahulena Hofmann, and I will introduce her as well. So she is the professor and holder of the SES Chair in Space, Satcom and Media Law at the University of Luxembourg. She is co-director of the Master in Space Communication and Media Law, and together with Tanja Masson-Zwaan, who is also here, co-author of the Introduction to Space Law. She is an elected member of the board of the International Institute of Space Law and lecturer at the Charles University in Prague. And she will introduce the framework of the ITU that is governing harmful interference, and then we will come back to questions. Thank you very much.
Thank you, Laura. So I have prepared a voluminous PowerPoint presentation, but I think because of time management, I would not to present it now. I think you can kindly distribute it among the participants, and they can then use it if they need so. So I would confine of couple of questions. First, we have to see that the ITU, the International Telecommunication Union, is an international intergovernmental organization with a very long history. So it started working already in the end of the 19th century, and its focus was not outer space at the time. We could not have any space flights. So the purpose was to avoid harmful interference among various services. And this principle to avoid harmful interference and to allocate specific frequencies to specific services the main working methods of the ITU. So starting from telegraph, from wireless telegraph and all other possible telecommunication, up to space activities, this way how to distribute the frequency spectrum, how to allocate specific frequencies to specific services remain as the main issue. So to do so, the ITU has developed its legal framework, which at present is encompassed or include the ITU Constitution, the ITU Convention, and radio regulations. And in this hierarchy, also one legal norm prevails above the other. So on the top is the ITU Constitution, then is the Convention, the radio regulations. What is an important measure of the ITU, how harmful interference should be avoided, is its inclusiveness. So today, the ITU is composed of 193 members, and you know that we have 193 members of the United Nations. There are some small, not overlaps, but just to see that it's a really global international organization. To also develop the instruments how to avoid harmful interference, the ITU, and it's very specific for this structure, is composed not only of member states, but it's composed also of so-called sectoral members. And this is a method which allows to include into its activities also the space operators, the academia, and in principle, everyone who is interested in its work. Then the third method, which I would like to underline, is its flexibility. So the ITU has the method of a regular, we can say 4 years meeting of these World Radio Administration conferences, in which the present methods are checked, are controlled, and if there is a need to allocate a new frequency band to a new service, this international conference adopts or measures which take the new service into account. So it is next regime which would be very difficult to change. The radio regulations which deal with the allocation of frequencies to services is a flexible instrument which is under modification every 4 years. And then the first method which the ITU adopted in the course of the time are its own institutions. So it is not only the international, the World Radio Communication Conference, but it's also a quasi-jurisdictional organ which is called Relations Board, which is a body composed of, let's say, 12 experts who are elected on behalf of their expertise, not because they are representing a state. In the contrary, they are elected only on their own behalf. And these experts, this body, is negotiating behind the closed doors. So there are no public records of the meeting of this body. And this body is competent, among others, to decide the disputes on for interference. And if the dispute cannot be decided, perhaps it's not a dispute in a purely legal sense of the word, it can be rather also a technical dispute. But if this quasi-dispute has not been decided by the Radio Regulations Board, it can be brought on the floor of the World Radio Communication Conference, which is competent to decide all issues which the Radio Regulations Board was not able to deal with. So there is already a well-functioning and experienced system of internal quasi-dispute settlement, which experience has a positive influence and contributes to the fact that there are no legal disputes in the legal sense of the word, the states members of the ITU. As my last remark, let me to remind you on the fact that the legal system of the ITU encompasses a protocol dealing with real dispute settlements. But to my knowledge, this protocol has never been used in the practice because it was not addressed by the member states. So until now, it was possible to conclude the disputes through negotiations, through bilateral negotiations, and if it was not possible, then on the board of the Radio Regulations Board or the World Radio Communication Conference. So let me to stop here to give also the others enough time to speak, and it would be to go into much more details and to answer your questions. Thank you, Laura.
Thank you very much for this great introduction. We will now turn to Alexandre Vallet, who will speak more about the dispute settlement mechanisms that are available at the ITU. And then again, we will come back to the questions. So Alexandre Vallet is and has been the current chief of the Space Services Department in the Radio Communication Bureau of the International Telecommunication Union, so the ITU, since November 2017. As such, he leads the team responsible for the maintenance of the International Registry of Satellite Radio Frequencies, which allows all countries around the world to coordinate their use in order to avoid radio interference in outer space. He began to work in the R&D Center of Orange, dealing with communication satellites in 2000. In 2006, he joined the satellite operator Eutelsat, where he was in charge of regulatory matters. From 2007 to 2017, he was the head of the Regulatory Affairs on Spectrum Orbit Resources Department at the French agency in charge of radio spectrum management. And so thank you very much for joining us today and for telling us a little bit more about the ITU and how it resolves disputes. Thank you.
Yeah, thank you very much for the invitation. In fact, Professor Hofmann already set up the scene of what is ITU and what we are doing. I will go directly to my main subject. So, as Ruth and Manuela explained, ITU is concerned with harmful radio interference. So we deal with the interference to radio signals. And first, I would like to start by putting a bit of context this issue of radio harmful interference. Here you have the percentage of radio spectrum that is assigned to satellite networks and which was free from reported harmful interference in 2021. So it's 99.95% of the spectrum we have in our database. So this is important to quote this figure at the beginning of this intervention, because this is important to understand that most of the spectrum is indeed free from harmful interference, which is good news. And this is because most of our rules, probably 90% or 95% of our rules, are designed to prevent harmful interference, not to solve them. This being said, sometimes harmful interference happens, and I will give 2 or 3 examples to present to our audience what it means to be interfered. The first case is interference to a scientific satellite, which is called SMOS. This is a satellite from the European Space Agency that is measuring the soil moisture and the ocean salinity at 1.4 gigahertz. And here you can see a map, in fact, of the various harmful interference spots that affect the measurements of this satellite. So this is the small spot in red and green. What is blue is considered as unaffected. You can see that there are some spots of harmful interference coming from radio stations that are unauthorized in this map. So that's another map. at a different time, and you can see that the interference evolves. So this is what a satellite operator from scientific satellite may see as an interference. Another case, this is a spectrum plot of some communications carrier on a communication satellite in K-band. And here you can see there is some radar interferences. This is because the uplink band of this satellite is shared also with some radar systems. And in fact, the emissions of radars can be captured or can be received by satellite receivers and can create some interference to the communications. So this is a second example of an harmful interference. A third picture that I would like to show you is that when some harmful interference happens, what is important is to be able to locate the source, especially when the interference affects the satellite receiver. And there are means to do so, which is called geolocation. So here is an example of what will be the result of a geolocation from a GSO satellite. In fact, from 2 GSO satellites, geolocating the source of harmful interference. So this is a test done in near Köln in Germany by the German administration. And you can see here that you have the ellipses. The ellipses show the uncertainty area. So when you make a measurement, of course, this is not entirely precise, but normally the cross is the location of the source, and the 2 ellipses are the uncertainties. So basically, you have to search around this area. So what this geolocation is used for is when you are receiving harmful interference, then you need to look at where is the source. To do that, you make first a measurement from the satellites, and you get this kind of results. And then you go on the ground with the administration having responsibility of the jurisdiction, and you're trying to find more precisely the source, but directly on the ground. The GSO satellites will not be able to have a much more precise location. And so these are some examples of real interference that happens and some means to suppress them. And just maybe to recapitulate or to sum up what happens in practice when there are interference. So when there are interference, in fact, it's because the satellite A is interfered by a satellite B with signals that is not desired. So generally, this is handled at the level of the satellite operators. A, in this case with B, at Network Operation Center level, and they solve the issue because both of them, in fact, have an interest to solve it. Because this, what happens one day to one may happen the other day to the other. So generally, network operating centers will keep good working relationship and will solve it directly. In very few cases, there may be a difficulty to solve it between operators. So this is escalated between the notifying administrations of each satellite operators, which will have interactions in a more formal way, especially within the context of the radio regulation, this treaty mentioned by Professor Hofmann. So if it does not work, if both administrations cannot solve it, then it is elevated or escalated at the level of ITU. And this is, again, what Professor Hofmann mentioned. We have an organ in ITU called the Radio Regulations Board. So, in fact, the escalation to ITU is a two-step process. First, you ask the Radio Communication Bureau to provide assistance. So, the 2 administrations, or one of the 2 administrations, will ask us to provide assistance in trying to find a solution. If it fails, then they will escalate the issue at the Radio Regulation Board level, which is a board composed of 12 people acting as experts, and that will formulate decisions that both administrations have to implement. Up to now, and since I'm working in the ITU field, so almost 20 years, I've never seen more than this step. So this has been the last step, and as Professor Hofmann mentioned, there is formally another step above that, which is the settlement of disputes through arbitration. So our constitution explains that there can be arbitration if amicable negotiation does not work. So we have a process for arbitration, and but to my knowledge, it has never been used until now. Not necessarily because it was not seen as useful, but because, thankfully, most of disputes were solved before at lower level. But it is quite interesting to see that when the member states of ITU decided to create a new constitution in the 90s, they wanted to include this article on arbitration. So there is this possibility of having an arbitration in case of an harmful interference dispute. Maybe one thing that I would like to conclude with is that maybe there are not a lot of arbitration until now on harmful radio interference, because the focus up to now was to really stop the interference, so stop the fact. There have not been a lot of discussion about seeking reparations for an harmful interference which had some commercial consequences. If there would be a kind of mechanism to seek, or a kind of willingness to seek reparations for harmful interference, then it is more likely that the arbitration procedure would be used, because this is quite certain that neither the Radio Communication Bureau nor the Radio Regulation Board are very well equipped to discuss reparations. So with that, I will conclude my presentations, and I will be happy to answer any questions in the Q&A session later. Thank you.
Thank you, Alexandre. If that's okay, I'll ask you a few questions now,
Sure.
because you said that you have never seen more interference than you have now. So do you think this is at least partially due to the launching of more non-geostationary satellites, or do you think there's no relationship between this new development and the interference you are seeing?
No, I think it's mainly because of the general trend to use the space more. It's not necessarily non-GSO or GSO, but I feel it's because the outer space is much more used now by communication satellites, scientific satellite, and so on, than before. A good example, for example, I presented the example of SMOS, this ESA satellite that is interfered at 1.4 gigahertz. In fact, SMOS was the first satellite to use this band and to monitor the Earth in this band. In fact, there may have been before the same situation, but there was no satellite to be interfered with. So we were not knowing that there was such a situation. So when the first satellite was launched and brought into use, then the situation appeared more clearly. But this is again because there is more usage of space that we see that. So yeah, it's not necessarily because of non-GSO.
Thank you. And maybe a more technical question. So if you receive a report about harmful interference, technically, what do you do? How do you know which satellite is causing the interference, and how is it identified? How is it addressed? Yeah, so when we receive a report, in fact, it depends on the level of details. Sometimes the satellite operator that is affected has already done a number of measurements and has been able to identify the probable or the likely source of interference, but has not been able to solve the interference with the identified satellite operator, so because of regulatory concerns or for other things. So we then simply act, as we say, as a third party, as a trusted third party. If the source of the interference has not been found, then we can rely on a number of space monitoring stations around the world, operated by national administrations, with which we have a memorandum of cooperations. And we can activate these space monitoring stations to try to locate the source of interference. So when this is done, then we contact the operator, which is a likely source, and we start to check if we can solve it. Thank you very much. And maybe now going back to Ruth, could you tell us a little bit about OneWeb's point of view, or not just OneWeb, but in general for satellite operators? Do you think this system is effective, sufficient? Do you think there need to be improvements, or what would be your general impressions?
Yeah, thanks. I think that most of us think the ITU system has been incredibly effective, in fact. As Alexandre said, the rules, the regulations, which are a treaty level obligation by every nation in the world, is really designed not to prevent any country from using outer space. Everyone is entitled to launch their communication satellite, but you do have to share the spectrum. There is only so much spectrum, and all satellites, no matter what their service, are really sharing the same spectrum. And so the rules are designed first, be aware of who has already asked to use that spectrum. There are filings and paperwork, documentation you can look at. Design a system, a new system that can share with the existing and planned existing systems. And as Alexandre said, it's self-preserving, or not, that's not quite the right word, but if I decide to be bold and just start broadcasting and I cause interference to another user, my users will also suffer interference. And so no operator wants their own business to suffer. And that is a mighty factor in both spectrum interference and physical interference. No one wants a collision. You lose your asset, you lose money, and it's very hard to replace those. So there's a great motivation to cooperate and to discuss situations with each other, such as we're doing now with this new situation, the astronomy situation. The physical issues are being dealt with not so much at the ITU, but almost one-to-one between existing operators. There really aren't that many of us. And those who are operational, our flight engineers, speak to each other very regularly. We get information constantly from the US and now from the EU about the position not only of our satellites, but approaching objects, whether an operational satellite or debris. And so we can maneuver. And as I said, we speak with each other. So the physical interference is also being done almost more as mediation, right? Arbitration implies, as Alexandre's chart showed, a top-level panel that makes the decision for you. Those are experts, and they say, we have heard both sides, and this is our decision. And I don't believe we've come to that point with either physical or radio or optical interference. And perhaps, in fact, if I may say, I'm not sure there could be a panel who were more expert than the participating operators. And maybe that's why it has never come to that, even within the ITU system. Who would know more than the 2 or 3 operators affected about movement, about interference, about mitigation?
Yeah, let's hope for the operators it stays this way, and the arbitration lawyers will have to wait. Going back to Mahulena, could you also let us know if you think the system is effective? I have read recently that because of the increase of launchings and of satellites now in space and planned in the future, it will become difficult for the ITU to continue at the same effective level as it is operating now, just because of numbers. But I would be interested in hearing your point of view on this.
Thank you, Laura, for this question. Start with the end of this question. So, of course, the ITU is not waiting that a catastrophe happens. The ITU is negotiating already for more than 4 years a system how, for instance, to register large constellations. So it has been adopted so-called milestone approach. How do you be aware of the fact how many satellites has been already launched, and to make them also to inform also the other operators about the large constellation. So by no means the member states in the ITU would be inactive. In the there is a lot of talk. There are new rules. There are modifications to radio regulation. So I don't think that the ITU would be becoming toothless. I don't see this danger by no means. And to answer to the start of your question, I think that the main core of the effectivity of the ITU is, and Ruth already mentioned it, is interdependability of the users. So it would be like to be in one street where we would not have any traffic rules. So I try to go in the opposite direction than the others. Most probably, I would make problems first to myself. So it's a technical dependent system, which brings also, and that's what makes it so surprising also for from my perspective, also states with very specific political systems to comply with these rules, because they are dependent on it as well. So it is this interdependability and it is this inclusiveness which, to my mind, make the system effective. And perhaps, but I have to say that these rules have been developed by mostly engineers. And as already pointed out, they are able to take a phone and to call to the colleagues that a problem can happen before they would start thinking about the legal methods.
Yeah, that does make a lot of sense. And yeah, I guess if it's in someone's self-interest to avoid harmful interference, that's probably a much bigger motivation than any legal system could be. But with this, we will leave the ITU behind for now, and we will turn to general international space law and to Tanja, who will tell us a little bit more about this. But first, I will introduce her. So Tanja Masson-Zwaan is Assistant Professor and Deputy Director of the International Institute of Air and Space Law at Leiden University and President Emerita of the International Institute of Space Law. She currently serves as a Vice President for Science and Academic Relations of the International Astronautical Federation, and she advises the Dutch government and other institutions on space law issues. And finally, she was also co-founder of the Hague International Space Resources Governance Working Group. Tanja, with this, I hand the microphone over to you. Thank you.
Yes, I unmute myself. Thank you. Thank you, Laura, for this introduction and for organizing this important panel. I presume you can see my slides properly. Yes. Okay. So yes, I want to perhaps broaden the discussion a little bit. We've been talking mostly about harmful interference in the sense of the ITU and radio frequency interference, but of course there are also other kinds of interference. And so putting it in the little bit broader context of international space law is what what I will try to do in the next few minutes, if I can go to my slides. Yes. So of course, we have binding international law that binds not 193 states like the ITU members, but the Outer Space Treaty of 1967 has 112 states parties, plus a number of states who have signed the treaty as well, which do contain some relevant principles that should be considered in this regard. The most important one being Article 9. I'll go in a little bit more detail on the next slide, but basically that article is the only one that does explicitly mention the words harmful interference and the avoidance of harmful interference with a duty of due regard and a duty of consultation. And this provision, this article, which is actually the longest article in the treaty, if you read it with 4 different sentences, is becoming more and more important as space is becoming more and more contested, congested, and the risk of interference and collisions increases. And of course, this is mostly the case in low Earth orbit, where we have an immense increase of not only objects, but also actors, which are not always the experienced satellite operators like OneWeb or the ones that were operating in geostationary satellite orbit. So there is an increased need of taking each other's interests into consideration. We can also look at Article 1, which of course says that exploration and use of outer space must be carried out for the benefit and in the interest of all countries, and that they are the province of all humankind. And then there are the principles of state responsibility in Article 6, of liability for damage caused by space objects in Article 7, and of registration, jurisdiction, and control, and confirming the ownership of objects launched into outer space in Article 8 of the Outer Space Treaty. Now, looking a little bit more in detail at Article 9, as I said, it is 4 sentences. The first 2 sentences contain the principles and the obligations. So first of all, states are obliged to cooperate with each other. That is, of course, something that we see a lot in the outer space treaties. It is a reflection of the geopolitical circumstances in the 1960s, when states wanted to preserve outer space for peaceful purposes. And this cooperation was really permeated into all the treaties, and also assistance in case of need. Due regard is an important principle that we also see in international law in general, which basically means that we have to look out for each other and consider each other's interests, the corresponding interests of other states. Then there are 2 obligations. First of all, studies of outer space and exploration must be done while avoiding harmful contamination and also adverse changes in the environment of the Earth. So here we're talking more about planetary protection and backward and forward contamination of either space or the Earth. And that states have to adopt necessary measures if that is the risk. And then the important one is in our case in sentence 3 and 4. First of all, if a state has the idea that its activity could cause harmful interference to the interests of other states, it has a duty to conduct prior consultation. And on the other hand, a state that suspects that the activities of another state could cause harmful interference to its space activity may request consultation from that state. So we can see that harmful interference is not prohibited per se. The only duty that we can read really in Article 9 is that duty of consultations. So what if there is this harmful interference? And I believe this could also apply to radio frequency interference, but also other kinds of interference. What is the duty? On the one hand, the state that has the impression that its activities will cause harmful interference is obliged to do prior consultations, but the state that risks to be interfered with can also request such consultations. Now, the question is, of course, what if the state whose activities are interfering does not respond, or that the consultations take place but are not successful? Does that mean that Article 9 has been violated? And if there is such a violation, what could be the methods of recourse? So we could, of course, look at the Liability Convention and one of the other 5 United Nations space treaties. Liability Convention of 1972 deals with liability of the launching state for damage caused by space objects to space objects or persons or property of other states. So of course, here the question is whether, if we talk about signal interference, whether that is damage caused by a space object, that may be quite disputable. Generally, the doctrine is of the opinion that there is a need for a physical causality to objects that physically collide with each other, or an object that crashes to Earth or something like that. And of course, beside that doubt whether that convention could apply, there is also the fact that in space there is a fault liability, so there would be a need to prove fault. We could, of course, also look at the draft articles on state responsibility, and there you would argue that there might be a breach of an international obligation, the obligation to conduct consultations. And if you would like to argue that, you could have recourse to means of dispute settlement. And there we come to arbitration, which is, of course, the topic of this, the main topic of this webinar. And we have, under the Permanent Court of Arbitration here in The Hague, where I'm also based, the famous special rules for arbitration of space disputes, which were adopted by the Permanent Court of Arbitration some 10 years ago, which unfortunately have not been put into practice, or perhaps fortunately because no serious enough disputes have arisen. So neither under the Liability Convention nor under these specific rules we have had any disputes. But that doesn't mean that there haven't been any instances of harmful interference, and I've just listed a few here that have made the news in the past few years. The interference by large constellations with astronomy was already also mentioned by Ruth. This is a problem that we have been observing in the past few years since the big constellations are being launched. There is not only interference with optical astronomy, but also with radio astronomy. And this is really causing a problem to the astronomical observations, which are, as you know, most often funded by public money. So this is a serious problem that has to be looked into. There was also an interesting instance of perceived interference of the Chinese space station by 2 Starlink satellites. And that was, according to China, putting into danger the lives of the taikonauts, of the astronauts on board of the Chinese space station. And the Chinese government took an interesting action. They informed the United Nations Secretary General and the UN Office for Outer Space Affairs of this instance of disturbance under Article 5 of the Outer Space Treaty, which was quite a surprising or interesting approach. Article 5, as you know, says that astronauts are envoys of mankind who should be given all necessary assistance in case of distress, and also asks states to inform the UN in case of special phenomena that they may observe. So China considered the danger posed by the Starlink satellites as a phenomenon that had to be notified to the United Nations, rather than asking for consultation with the United States under Article 9. They approached the United Nations. So this was quite an innovative interpretation of Article 5, but could be an interesting means perhaps. And then also a couple of years ago, there was a near collision between Aeolus and an ESA weather satellite and another Starlink satellite. There was a conjunction warning, which in the beginning was not too serious, but then became more serious. And despite the first contact, when ESA tried to contact SpaceX again, there was no answer on the phone, and therefore ESA basically decided on its own to move its satellite. So I've listed here just a few of the articles that could be relevant of the Outer Space Treaty. Article 9, obviously. Article 6, possibly. States should, of course, authorize and supervise activities. Perhaps there is an increased need for supervision. Article 11, which allows states to give information to the United Nations, perhaps could also help. And then perhaps the Article 5 approach that I mentioned earlier, but also certain rules of soft law, such as the guidelines that are adopted by UN COPOS. So just to end, I've written down here a few solutions or possible avenues. And I believe that we should look not only at global level, of course, ideally these should be agreed at United Nations level, but possibly also regional, thinking specifically of the European Union and ESA context, and sometimes also at the national level. The long-term sustainability guidelines of COPOS that were adopted in 2019, I think are an important tool. They have to, of course, be implemented at national level. These are voluntary guidelines. We see at several levels discussions on space traffic management. This will also help to keep low Earth orbit sustainable, to avoid collisions. That will require space situation awareness and space surveillance and tracking, improved tracking mechanisms, and sharing of SSA data will be important. And we see several initiatives, both in the United States and in the European Union, for instance. Protection of the dark and quiet skies has, after several years of battle, been accepted last year as a new agenda item at COPOS, at the Scientific and Technical Subcommittee. So that is also on the road to being discussed, and perhaps some measures will come out of that. And I think also that the better implementation of Article 6 should be a possibility, possibly environmental impact assessments. And also we should remember that Article 6 is not only about authorization, but also about continuing supervision. So there is a duty to continue this oversight by governments. And lastly, and I think definitely not least, it is also very interesting to look at certain industry initiatives. Ruth also referred to that. We've seen Starlink, that was in discussions with the astronomers, for instance, about darkening their satellites to avoid the reflection of the sunlight, but also the World Economic Forum's initiative and others for the space sustainability rating, which can help to incentivize industry to take action, which is, of course, and Laura, you also referred to it, always preferable to imposing sanctions or whatever. So if you have a good rating, you can perhaps get better insurance rates and so on. So I will leave it to that and stop sharing my screen, and thank you for listening.
Thank you very much. So you mentioned that, for example, the Chinese preferred Article 5 to Article 9, but Article 9 is actually a really good tool, you would think, for operators, because it allows international consultations. So why do you think they preferred Article 5, and should Article 9 be more promoted to be maybe?
Yeah, I was quite surprised, actually. When I think of phenomenon in Article 5, I think of some biological phenomenon, you know, some discovery of life or something like that. That is how I have always read Article 5, and well, perhaps you could say Elon Musk is a phenomenon. I don't know, but perhaps the reason was that Article 5 allowed to contact the UN, whereas Article 9 is about contacting another state, and perhaps they wanted it to be more public. But it's really surprising why Article 9, to my knowledge, has actually never been activated. There's no public record of consultations taking place under Article 9, and I think that especially perhaps in the context of the dark and quiet skies, there could be states that are important supporters and funders of astronomy that could take this article and request consultations, and perhaps it is perceived as being diplomatically sensitive, that there are other interests at stake. I'm not sure, but it is a fair mechanism which should not be anything heavy. I mean, as a first instance, I think it should be something that hopefully will be used as an opportunity to solve these issues.
Would you think that the current mechanisms are sufficient, or do you think UN COPUOS needs to address these issues to maybe think of better mechanisms to solve future disputes, both in the optical and the frequency interference space?
Well, I think we have certain we have these mechanisms, so we should also use them. But I definitely also think that there are other ways, like what I said, to implement Article 6 in a better manner, or to encourage states to do that authorization as well as the supervision, so that we know that all these aspects are taken care of. I don't necessarily think that we need new measures, but that we should use the tools that have been provided by the treaty.
Okay, thank you very, very much. I have a question to all of you, but maybe most to Ruth, which is, so you mentioned that the formal dispute settlement mechanisms are not really needed because the companies that are active in space are the best experts there are. And from what I read, this has been true for a long time, but might be changing at the moment just because there's so many new and smaller companies that are entering space. So one of the questions I had was, do you think that this will continue to be a viable situation to just communicate with each other? And the other thing is, the treaties provide for dispute settlement mechanisms, the ITU and also the Outer Space Treaty and the Liability Convention at a state's level, but not between operators. So from your practical experience, do you think dispute settlement mechanisms at a private level will be needed, or will the current system continue to be sufficient?
All great questions. I think the short answer is no, the current system will not be sufficient to take us into the future. I think when the Outer Space Treaty was written, it was inconceivable that there would be private companies. We even have individuals who now have the money and the capability to use outer space. So those treaties were not written to solve that situation. And I think there was also a question in the chat that addressed the aggregate interference. It might be possible for two individual operators or nations to have a discussion and resolve the situation. But what do you do if, say, all of the LEO companies and countries are perfectly happy with their behavior, but the aggregate effect of their operations interfere with astronomy? So that's a different, not necessarily a bilateral conversation, and I'm not sure that structure exists. And I think all of us here on this panel and also participating are here because we recognize this is a problem that we are living right now, and we must keep talking until we find a way to resolve these bigger, more complicated interference issues than were conceived of 60 years ago. I do think so far things have been handled well. Really, honestly, I'm not painting a rosy picture just because OneWeb hopes to use the outer space environment. I think you've mentioned situations where physical interference, optical interference, radio interference have been noticed and discussed and resolved. So far so good, but no, I think it is insufficient for the massive expansion into outer space that I think we all see coming from all kinds of usage.
Thank you very much. I don't know if one of the others wants to add something to this answer.
Well, yeah, maybe just two points. One is that I feel that if we speak about unintentional interference, meaning not using interference as an offensive tool or as a tool to generate harm, but really something unintentional, I feel that this will never go up to the arbitration level because both sides will want to solve it, I would say, in a quicker manner between amicable negotiations. Very often, most of the harmful interference cases that are unintentional are solved even without the intervention of ITU in a matter of minutes or hours, most of the time hours. So it's solved very, very quick. when it goes to intentional interference, then we enter a completely different subject. And of course, a much more contentious one that would exceed this webinar. The other point, I think, is that it all depends whether there would be a search for compensation or for reparations about the effect of the harmful interference. As long as the focus is on stopping the radio interference, I think the arbitration may be a bit too heavy to solve. But if we go to the point of should we compensate the effect of an harmful interference events, then maybe arbitration will come into play. And otherwise, I agree with Ruth that we will have more and more for the case of harmful interference in all the aspects explained by Tanja, and that may open the need for other mechanisms, including arbitration, or maybe I would use the word arbitration-like, maybe not the full arbitration law as we know it, but using a panel of experts to find a solution, not necessarily using all the arbitration law, but using at least a panel of external experts to find solutions. Thank you.
So if I may, if I may, even the case of the intentional harmful interference caused by Iran a couple of years ago was dealt with the Radio Regulations Board. So it was possible to find a solution at the end, which was based on some sort of compromise, but there was no need to create an official arbitration body. And I would like to use the opportunity and ask you, were there already cases of seeking the reparation? Was there already discussion of to deal with it? I find it very interesting.
No, not yet. There have never been some public discussion about that. But that always surprised me that when you have, I would say, a long interference affecting commercial transmissions, that there is no discussions about possible reparations. This is probably the reason is that up to now, most of the service agreements that you have with your customers are excluding, I would say, force majeure events where, for example, harmful interference is one of these cases that is often used. So you don't compensate your customers, therefore you don't seek any reparations. On the longer term, I feel that what Ruth explained, that the future with non-GSO is going to be more complex, with probably a blur in the definition of harmful interference. As Ruth explained, what is really harmful? Is it intolerable? Like that? Then this may create more requests for looking at, is it really force majeure? It is really not subject to compensation. But that's, I would say, something completely new that we have not seen in the world of GSO communication. Because GSO communication, harmful interference is binary. It's either you are interfered and the communication is broken, or you are not interfered and the communication flows. But with non-GSOs, there will be a lot of nuances that may open new fields of research and new discussions.
Thank you. It's very interesting.
Yes, I agree. And actually, so the ITU sets out rules to determine which satellite systems can use which frequencies. And if my understanding is correct, those agreements or this coordination between the satellite systems is often recorded in a sort of contract. And Elina Morozova wrote an article on the fact that those contracts can and could contain arbitration clauses. So I don't know if you want to comment on that, or if you think this could be an interesting tool in the future, not just maybe to resolve interference cases, because as Alexandre mentioned, those require immediate resolution, but maybe also to determine who has the right to use which frequencies in cases of disputes over the use of those. I don't know if anyone has a comment on this, otherwise we can leave it as a doubt for the future.
Well, I guess it's always a good idea to foresee what you hope will never happen. So including provisions in a contract on what if there is a dispute, how will we solve it? For instance, by arbitration, referring to this or that tribunal or these or those rules is always, I think, a wise solution. You always foresee in a contract these things and then hope you will not use them. And I think that most contracts, which are of course not always public, but most of them do contain arbitration clauses.
And if I may, there is a public example of that. This is a situation between SES and Eutelsat in the years 2012-2013. They had a dispute that was both on commercial terms and on radio issues, and they went to an arbitrage. They went to an arbitration court. The arbitration went on. I think they finally came to an agreement before arbitration was finalized. But this is an example where, in fact, it indeed happened. It stemmed from, as you mentioned, a coordination agreement which contains such clauses.
And I was just going to add that the OneWeb coordination agreements with other operators are not written like traditional legal contracts. They don't have clauses about arbitration or mediation or which legal system will be used in case of dispute. It is written simply under the regulations of the ITU. In accordance with this regulation, we've come to an agreement about how we're going to share the spectrum. And that's it. And so effectively, the ITU process for appealing to the RRB and then ultimately arbitration is implied, but it's not explicit in these agreements.
That is actually very interesting. I think the main difference would be that if you included arbitration clauses, you could have commercial private arbitration, whereas the ITU arbitration obviously would involve the respective states. So if this were to happen more frequently in the future, it would probably be preferable to have access to commercial arbitration.
But the question again would be, and what panel would arbitrate? If not the RRB, they truly are the experts in spectrum, and so it would create a binding, an opportunity for the operators to commit to accept the RRB's proposed solution.
Yeah.
Interesting.
I think
yeah.
Any of you would probably be a good choice as an arbitrator in those cases, but I think this is probably still quite far away in the future. So maybe we can have a quick look at the Q&A session, rather at the Q&A questions before we close. So I think the first one has been answered by Tanja. So I think the Claims Commission, correct me if I'm wrong, but has never been used at all, and also not in harmful interference disputes.
No, correct. Yeah, sorry, I was trying to type some answers to there, so I wasn't paying attention. No, there has never been a dispute settled under the Space Liability Convention. The only time that there has been a preparation of a claim was in 1978 when Russian Cosmos debris fell in Canada, but that was in the end also settled by compromise.
And I think Mark Mayer's question refers to the standard setting of judgments. And I don't know if one of you want to comment on that, but I think any public judgments, especially by international tribunals or courts, will obviously influence the interpretation of the existing treaties.
Yes, in a way, we when there was the Iridius Cosmos collision some 10, 15 years ago, many of us space lawyers were saying that we were happy that we were going to have a case to interpret what is a space object, what is fault, what is the fault standard, and so on. So yes, having jurisprudence, of course, always helps in interpreting the treaties in an authoritative manner. If there is a judgment by an arbitral tribunal or by the International Court of Justice, that would set precedent. But on the other hand, I think also one of the reasons why it's not happening is that the parties in a dispute would prefer to settle it perhaps behind closed doors, to not have things public. So there is this tension between, on the one hand, the desire to have jurisprudence, and on the other hand, space being very sensitive, expensive, dual use technology, and so on. So maybe that is one of the reasons why we do not have jurisprudence. I'm not sure.
Yeah, and this is, for example, also where private arbitration obviously is less advantageous, because the awards are not necessarily public, and so part of the interpretation will never be known to others.
That's a big benefit. Yeah.
Yeah, if I may, a follow-up. So there is the tendency to make judges or arbitrators expert also in this very technical area. And I would call as an example the Dubai Financial Investment Courts, which started a huge action globally, which was aimed to learn, to lecture, to give the expertise to the general judges of this Dubai court. So also these judges were prepared in space law and telecommunication law to be able to settle cases also in a form of arbitration in this area. To my knowledge, also they have not had any case which would deal with space or telecommunication. I got only one report that they were dealing with something dealing with electronic payment means, but no case in space and telecommunication yet.
And if I may also add something, is that you should not forget also that in international law, the fact that the mechanism exists and is a possible recourse is often a good means to put, I would say, pressure or gentle pressure on the member states and the private sector to find a solution under amicable negotiations. So in this sense, the arbitration mechanisms that exist and the fact that they are mentioned, if they are not used, it doesn't mean that their purpose has failed. They are also here to make sure that people exhaust all possible rules before going to arbitration, and therefore to try to find, I would say, amicable solutions. Until now, it has been possible. As we all mentioned, I think I'm not so sure that it will continue to be the case in the future years, simply because of the multiplication of the cases.
Yeah, no, I agree. And then there's one last question, whether we can evaluate harmful interference as a transboundary harm in international environmental law. I don't know if any of you would like to answer that.
I don't think that it's the same. There is a legal definition of harmful interference, which is given by the radio regulations, which says that it is an interference which makes a reception of a signal almost impossible. So close to impossible or impossible. And so I don't see there any harm to an environment. It's a harm to a radio signal. So the object is the radio signal. Of course, we can compare these two areas, but I would not say that they are the same. They are different scopes which are infringed or which are touched.
Yes, I totally agree. So I think with this, we have answered the question. Thank you very much for accepting our invitation and for being on this panel today. And I will hand the microphone back over to Elena for a few closing words.